Hey out there, legal warriors. Do you need a lawyer for a restraining order in Washington State? Do you need one, or can you get away without one? Well, it sort of depends on which side of the order hearing you're on. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes and actually handling protection orders as well for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it. More people get the help they need. Now, I'm just going to jump right into it. What do you mean by a protection order or a restraining order? What do you mean, Lance? Well, there's a law in Washington State. It's under RCW, that's Revised Code of Washington 7.105. If you to look that up on Google or wherever you search, you'd come up with a statute, and it says there's a whole bunch of different types of petitions for protection orders is what the official name is, but most of us out there in the world call it a restraining order. There's where one person, the petitioner, can ask that the freedoms of another person, the respondent, be restrained. The typical restraint would be, hey, court, I don't want the respondent, the person I'm mad at, to contact me if I'm the petitioner. Don't want them to be within 1,000 feet of me. Don't want them to be within 1,000 feet of my residence, or any amount of feet, but the default in Washington is 1,000 feet. My workplace, my kids. It's pretty strong what can happen in these orders. And so if you've watched other videos on this station, there's lots of videos I have about how a restraining order works. So I'm just not going to go through the entire steps of a restraining order here. But needless to say, there's a difference about whether or not most people need an attorney, depending if you're the person asking for the restraining order. I'm the one who wants someone restrained. That's the petitioner. Or if you're the unlucky person who's getting served with a restraining order, the person called the respondent. Now, the legislature wrote this law to put all the protection orders under one statute about 2 years ago. And if you remember my video on that, I think the title of the video was, "This is a Disaster." That was my prediction when I read the session law, and I was right. It is a disaster. Legislature, once you start getting served with protection orders that shouldn't be against you, maybe you'll actually put in some safeguards for the respondent. But it's pretty pathetic the way the law works now. And if you're a respondent, definitely the odds are stacked against us. But everything favors the petitioner in the statute. Apparently, the legislature thinks that if you're asking for an order, whatever you're saying must be true. Because that's sort of the way it works, right? The judge rarely will deny a restraining order that has any type of decent pleadings at all in it from the petitioner. So basically, for someone to get the order, if you're the petitioner, it's designed for you to not need an attorney. Now, sometimes the petitioner will get an attorney because it's not easy doing legal stuff. But from the petitioner's point of view, they're going to go typically online nowadays. They're going to download a packet. They're just going to follow simple instructions. What bad did the respondent do? They're going to write in what bad the respondent did to them. They're going to submit their evidence. They're going to be seen by a judge typically the next day. Ex parte, one-sided. They're going to swear what they wrote is true. And the judge is just going to give them a temporary protection order restraining the respondent. And for the most part, they're going to make the police go serve the respondent, and there's going to be a new court date 2 weeks from now. So if you're the petitioner, if you're the person looking for restraints, the system is designed for you to not need an attorney, although we do represent plenty of petitioners because it is hard to do. So if you have need of a protection order and you want to get help, reach out to someone and telling them that you want to be a petitioner, and then hopefully that attorney can go through with you your ability to do it on your own or not. I'd say out of every 10 restraining order cases we handle, probably two are on the petitioner side and 8 are on the respondent side, because given how positively it's set up for the petitioner, hopefully you're not having to spend money for an attorney. You'll get a better result typically with an attorney, but it's designed for you to do it without one if you're able to. So what if you're the respondent? You get served with the packet. Well, you might guess absolutely 110%. If you can get an attorney, you should get an attorney. Now, the caveat to that is, and you might find this unusual, if you were people calling my office, if we look at the packet the respondent is served with, quite often we'll say it's not worth hiring an attorney at times because of how rigged the law is against the respondent, that there might not be a reasonable way for the respondent's attorney to write a response sufficient enough to defeat the request for an order based upon how slanted the statute is, RCW 7.105, in favor of just believing the petitioner. It takes a very brave and daring commissioner or judge to go out on a limb and deny someone a request for a protection order in many cases, especially domestic violence protection orders. A little bit more so in an anti-harassment. It's a little easier to deny if there's neighbors, but still, it's a more likely than not standard, and it's hard work to fight. So you may contact an attorney, and they may look at it, and they may say, hey, it may not be worth the money for you to bring in an attorney to do it. Sometimes it may be worth it to bring in the attorney to try to negotiate it, which might be less expensive. But sometimes the attorney does have a fighting chance of winning once they look at what you were served with. But no great attorney, at least, is going to get involved in every case because attorneys don't like to lose, right? We don't want you to lose, and we don't want to take a bunch of fees from you, at least if my firm doesn't, if we don't think there's a reasonable chance to have an outcome that is favorable for our client, right? And so people that don't like attorneys, I'm sure not fit with the stereotype of what you think about attorneys, and I'm sure there's a lot of attorneys who will just take whatever because they can make money. But if you're going to a really good attorney, they're going to be really busy, and they don't want to waste their time fighting a losing fight and disappointing people that they're trying to help, their clients. So what are the downsides of bringing on an attorney? Well, in many counties, they have sufficient funds to appoint an attorney for free to the petitioner if the respondent shows up with an attorney, right? Snohomish County pretty much always is doing it nowadays. King County, not as much. Pierce County, I see it a lot. But talk to whoever you're potentially hiring if you're a respondent to see what the effect is of the case, right? If the case isn't a great case for the petitioner, it may not matter that they appoint them an attorney. And sometimes we like them appointing an attorney to the petitioner because it gives us someone to negotiate with, that speaks the language and knows what the ins and outs of the law are, then instead of dealing with the petitioner, him or herself. But if you bring in an attorney, they will likely appoint an attorney for the petitioner. Not all the time. If it's a sexual assault protection order, then they're required to appoint the petitioner an attorney. There's a special rule for that most serious allegation in all these types of protection orders. When do you not want an attorney to come in? Well, if for some reason you think the petitioner is not going to show up, or you've heard through the grapevine they're going to drop it and they're not going to show up, well, you don't necessarily need an attorney for that. Or if you're a pretty good writer, right, and you can write a good response on your own, you have some experience and you can sort of follow the instructions, follow what the court says, watch some more of my videos to get some idea generally how the process works. Again, these videos aren't legal advice, but it gives you an idea. Then you may be able to go without an attorney. And most people do have to go without an attorney because this is sort of a specialized niche. We're not allowed to say we specialize, we don't, but it's a very unique niche in the law. And most attorneys that I know don't want to handle respondent work under RCW 7.105 because it's such an unfair fight. Also, the time frame is really short. A criminal case might take 6 months to a year to resolve. These order cases are generally going to be over in the most part, 2 to 6 weeks. Most of these order cases will be resolved. If attorneys get involved on both sides, it could go 3 months, 4 months, but it goes pretty quick. So what's the answer to the question? Petitioner, designed to do without an attorney. You'll benefit from having one. If you're really busy, you should probably get one. Respondent, if you can get an attorney, you should. Very hard to win on your own. There are some exceptions. I have coached some people into winning on their own, occasionally using your own voice as an advantage over the attorney, use the attorney's voice, but it depends specifically on what the petitioner is claiming. It depends specifically on how the petitioner might present and how the respondent presents. Each case is unique, so it takes a lot of experience to figure out what to do. And if you're having to deal with this on either side, I know it's not a fun time, and I hope you found this useful. So if you found this useful, please like and please subscribe. More people get to see it. More people get the help they need. More importantly, if you need a protection order, restraining order, you got to serve with a protection order, restraining order in Washington State, and you think you need some help, feel free to reach out to my firm. We can't guarantee what we'll take or what we won't, but if we get on board, we'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.